Let's bring in Boris Bytensky, who is a lawyer, to give us his take on this. Boris, we now have the latest, the judge ruling against Meng Wanzhou. What do you think?
Well, truthfully, I think this is the decision that most in the legal community expected. It was the decision that was easiest to write because, as the judge ultimately found, had the same conduct occurred in Canada, even in the backdrop of sanctions against Iran, it still likely would have constituted a fraud, and that's exactly what the judgment today came down to. So the way that the matter was analyzed was, had a Canadian person in Canada been dealing with a U.S. bank and misrepresenting something to a U.S. bank for the purpose of skirting U.S. sanctions against Iran, that would constitute a crime in Canada. And so ultimately, the court concluded that this was more of a matter of fraud. And because of that, the double criminality aspect of extradition was satisfied. This part of the ruling went against Ms. Meng, and the case continues.
We're just going to show again that double criminality because it's important to focus on this if we can show that, what exactly it meant. So today's decision is her alleged crime in the U.S., a crime in Canada, and the judge deciding, yes, it could go ahead here. So now what happens, Boris?
So this is a little unusual because, unlike most extradition cases, there's a separate argument that Ms. Meng's advancing about the violation of her rights upon arrest. That's going to be set for argument in June. To be candid, it's a bit of a long shot. I think this is an even tougher argument for her to succeed on at the judicial level than the double criminality argument was. So the argument will be advanced. Obviously, I don't want to prejudge anything, but these are very rare in extradition proceedings to result in a stay of proceedings. She would have to show that the misconduct, even if there was any, was not just some violation of her rights, but it was so significant that it would effectively shock the conscience of ordinary Canadians to allow this case to proceed, justifying a stay of proceedings. So I think it's a real uphill battle for her at the next phase, but that is the next phase that's going to be determined by the court. And if that argument also fails, she'll then be through the judicial phase of it, and it will be turned over at that point to the Minister of Justice Lametti's office to determine whether or not she'll be surrendered to the United States.
Yeah, let's just show the living conditions as well, Boris, that she has been placed under house arrest here. She is out on $10 million bail in Vancouver, 24-hour surveillance, a curfew of 11 o'clock at night. She has to wear a GPS tracer on her ankle. She's living in a 7-bedroom mansion in the Shaughnessy neighborhood of Vancouver, and we know that friends and work colleagues can visit her. Will any of this change, do you think?
No, I don't think that'll change unless there's information that hasn't been revealed publicly. So assuming that there's been no change in anything that she's done or accused of doing, that the bail conditions are almost certain to continue as is, and they'll continue for some time until the judicial phase is over.
We're just showing some video of her coming in to the courthouse moments ago, and you do see the ankle bracelet that she's got on as part of those conditions here. There's also the idea of when she gets extradited to the States. I mean, how long does that kind of process? And we're showing the video again. You can see it clearly on her left ankle there. How long does this kind of thing take?
Well, if you remember the Karl Schreiber matter, or the extradition matter from a decade ago, that took years, and this one can as well. So between the remaining aspects of the judicial phase, between the decision in the minister's office and all the appeals that are permitted, potentially all the way up to the Supreme Court of Canada, this is a process that should be measured in years as opposed to months in terms of what's left.
Is she able to appeal today's decision or no?
Yes, not yet, because today's decision isn't actually the final phase of the judicial process. We don't have interlocutory. We don't get to appeal on a decision-by-decision basis. We get to appeal on a phase-by-phase basis. So when the judicial phase is fully complete, including the charter argument that's pending, if she loses that argument as well, she's likely to appeal both rulings, the one today and the one that's going to be made in the future about the charter aspects of it. She'll appeal both of those to the British Columbia Court of Appeal.
Boris Bytensky joining us, legal analyst.